Judges of the United States Court of Appeals for the Second Circuit, oyez, oyez, oyez. All persons having business before this, a stated term of the United States Court of Appeals for the Second Circuit, draw near, give your attention, and ye shall be heard. God save the United States of America and this honorable court.
Please be seated. Good morning, everyone. And happy 2026 for those of you for whom this is the first court appearance of the year. We have 3 cases being argued today, and I understand all counsel are present. We also have 3 cases on submission, and let me read through those and tell you that the court will take all of those under advisement. We have United States versus Nash, 25-1658, and consolidated with 25-1662. We have Rivera versus United States, 23-110, and United States of America versus Lindsay Applewhite, 24-1670. We also have a number of motions on today's calendar, and the court will also take those under advisement. Before I do call counsel up for argument, let me remind you that there is a black switch on the right side of the podium that raises and lowers the lectern. So please, when it is your turn for argument, I would ask you to take a second. We will not deduct any time from your argument time. Raise and lower the lectern to make sure that the microphones are as close as possible to you, and microphones as well. We want to make sure that we do not miss a word of what are sure to be extremely helpful arguments from everyone. So with that, let's call United States versus Moses, 24-1341. I understand we have Attorney Bachrach, and you would like to reserve 3 minutes for rebuttal. Is that right?
Yes, Your Honor.
Very
I'm
good.
short. I need a moment.
Yeah, please, please, please.
Thank you, Your Honors. Samori Moses was a mountain of a man, about 6'4", all muscle, raised by his own mother to be a terror on the streets and to be, in fact, a pimp, for lack of a better term. This is what he knew. This is who he was, and he owned it. He's an individual so imposing that if the most dangerous criminals were walking down the street in the other direction, they would move to the other side of the street to avoid him. That's the kind of man he is. An individual who a simple slap or multiple slaps can, in fact, kill, even if he did not mean them to. And in fact, that's relevant here to both counts, both issues that are being raised on appeal. Because there is no dispute in this case that Mr. Moses did not mean to kill, did not intend to kill Miss Foster. Miss Foster was both his paramour and his employee, and by that I do mean he was one of the women that he sex trafficked. And this is not a gentle case, it's not a genteel case. It is a terrible case. It's a, unfortunately, tragic case. But intent matters, because intent matters to what the crime is. And what is it exactly that he pled guilty to? And what is it exactly that he should be sentenced to?
Could we just, and I think I appreciate your arguments, and they were, I thought, laid out in your brief. So why don't we get down to brass tacks? I understand that your attack on the conviction is twofold. You're attacking the knowing and voluntary nature of the plea.
Yes.
And you're attacking the adequacy of the factual basis. Am I correct that there are 2 parts to your argument, or?
And they're interwoven. Yes.
Well, that's what I was wondering about, because with your knowing and voluntary argument, normally I think of that as asking whether the defendant was apprised of the nature of the charge, by which I mean the elements of the offense. But I thought your brief arguably bled the factual basis issue into the knowing and voluntary argument.
It does.
Could you explain that? I'm just trying to analytically understand. I understand the factual basis issue.
Right.
But I'm not sure I understand the nature of your knowing and voluntary.
The argument, in essence, and if you look at the very precise language that he made when allocuting. So I intentionally inflicted serious physical injury on Leandra Foster, which proximately caused her death. A lot of thought went into the exact language that would be used. And the question is whether or not that language is sufficient. So he understood that he assaulted someone and that as a result of the assault, he killed that person. However, is that enough to establish the offense when there was a defense to that conduct?
Now that's
which
a
was not
factual
raised.
basis
Right.
argument, and I understand that. I think there's a strong argument made by the government that you've waived it because it was a jointly crafted allocution that the defense affirmatively represented to the district court. You need not ask my client any questions because this is a sufficient factual basis. So I don't know how your client gets over that hump.
I would argue forfeiture, not waiver, but I
Well,
understand
no,
what you're
I think
saying.
if you say to the court, don't ask any more, this is enough, Your Honor. I think that's an affirmative representation. It's not, it never came up. Oops. That's an
but-
affirmative
well,
saying
but-
this
so-
is enough.
Both parties affirmatively said do not do so.
Well, it
In
doesn't
fact,
matter what the government said. The government could have said anything they wanted. The question is whether the person now complaining about something that happened in the district court affirmatively represented to the district court, this is how we want to play it. Don't do anything differently. You can track the statutory language, Your Honor. That's enough. And the court said, maybe I need to ask follow-up questions. And the representation for the defense was, no, you don't.
What
So-
you can't waive, however, is whether or not the defendant, when the attorney crafts the allocution, and when the attorney and the government work together on a plea, however it may be.
Well, the
defendant is the
statement
one-
was affirmatively that we've worked closely with Mr. Moses about this.
Exactly. And it's the understanding of the defendant. Did he understand that when he was pleading that this language was also sufficient to satisfy manslaughter, that this was in fact
But how do
sufficient for
you
manslaughter?
just analytically then break out for me the knowing involuntary as opposed to, let's assume for the sake of argument that you've waived a challenge to the factual basis. What's analytically left of the knowing involuntary claim? Just so I know what box to put
That
that
he did
in.
not knowingly and voluntarily recognize that there was a defense to the charged conduct, the defense being manslaughter, the defense being crime of passion, which reduces the offense from murder to manslaughter.
But how do you, it's normally not part of the allocution to get into defenses that can be raised. It's a question of whether the elements are there. You don't have there are lots of defenses available. And when you plead guilty, you waive them. But you don't have to tick off a litany of defenses that are being waived as part of the allocution. How do you get past that part?
Well, you still have to ensure that the defendant knowingly understood the elements of the offense and the nature of the charge.
Yeah.
And he's pleading guilty here, believing that what he is saying is sufficient to satisfy only murder, not recognizing and never being asked by anyone, myself, my co-counsel, the government, or the court, whether or not he realizes that what he said here isn't actually murder. It's manslaughter, at least based upon the facts known at
But
the time. in the record.
it was presented to the court as sufficient for the plea, and both sides adhered to that. And you were counsel for him at the time.
I was. I didn't recognize, I will candidly admit, I did not recognize that defense at the time we were negotiating.
Okay, well,
I
there's
sort of
another-
said in my briefs, but
There's another doctrinal point that I think is worth discussing here, and that's the whole concept of invited error, where if the judge erred, was the error invited by the defendant? In which case, the defendant can't take advantage of it.
if it was intentionally invited by the defendant, certainly. It was certainly not intentionally invited here. However, the focus, of course, and candidly, I admit this, I was counsel below, as was Mr. Houston. Our focus throughout was, more than anything, was on the sentencing. Was it murder one or was it murder two? The parties crafted the allocution that we did, believing that it allowed both sides to argue what they believed to be the correct interpretation of those facts. So believing that. That's what everyone was discussing. So so when discussing it, even with Mr. Moses, there was no conversation about, oh wait, it's something else. The assumption was it's murder one or murder two.
But that
And we
seems to
believed it's murder two.
demonstrate exactly why waiver would apply here, because it was a tactical, a very, probably very intelligent strategic. The battle on guilt. Let's fight the battle at sentencing, because maybe you can get a better sentence here. And if you admit it all, and then you can still leave open your version of the story, which is it was not the impact of the blows that immediately killed the victim, but we'll simply admit that the impact of the blows, whatever, left her in such a shaky state that approximately caused her to slip and fall and hit her head. And that is a less gruesome story for the defendant at sentencing. And I think it sounds to me like an excellent strategic decision if you're the defense. It didn't work in the end, but not every strategic decision works. But that's why we talk about waiver when someone consciously makes a bid saying, look, this may win, this may lose, but I have a reason we're doing it. Then we usually say it's waiver, not forfeiture, right? Because it's something consciously undertaken. And it was with a knowledge of the risk. This may play out or not, and the chips will fall where they may.
It was certainly a conscious decision to plead guilty and make the sentencing battle be about, is it murder one or murder two? What the defendant did not consciously consider was whether or not it was murder at all. It was killing. And as I said, this is not an individual who went to college. He didn't go to Sarah Lawrence or Yale. He grew up on the streets. Killing is killing. And that much he knew he did. He didn't knowingly recognize, he didn't have the conversation about, what about that next step? Can you kill someone and it not be murder? But I am out of time, although there was a point two.
Why don't you take one extra minute?
Okay, thank you, Your Honor. And on point two, I recognize, again, it's an uphill battle because of the Amendment 591. I concede that's really what I'm up against.
And I guess I will ask you, since you're on the point, I thought the district court said expressly, guidelines, schmidelines, I would oppose the same life sentences anyway. So aren't you also up against harmlessness? I guess I'm not really sure.
I'm also up against harmlessness.
Okay, all right, very good.
However, there is numerous Second Circuit cases cited in the brief and elsewhere that says that the lodestar of sentencing remains no matter what language the judge says. You still have to consider the starting point, because that does make a difference. And if it's the starting point is the murder 2 guideline versus the murder 1 guideline, that means the starting point is 360 months to life rather than a life, which means he would if he got a 30-year sentence, he would actually walk free someday. He's already been in jail for about 9 years at this point. So that's very real that he would get an opportunity, assuming he lived throughout jail, but that he would be free again. So there is a qualitative difference there, and the starting point does matter and should overcome harmless error. But on 591, obviously 591 makes the guidelines mandatory. It makes the cross-section mandatory. But it can only be constitutional if it's constitutional as applied. And that is the case for numerous statutes. I can give an example. Section 702 of the
You're saying the cross-reference is unconstitutional? Mandatory cross-reference is unconstitutional?
As applied.
Even though it's advisory? Whole thing is advisory and a judge can ignore it?
Well, 591 states that you have to start with whatever that may be.
Right, but Booker says you can also ignore the guidelines. You can just say, you know what, thank you for the advice, but not interested.
Well, if that's the case, then it should have been ignored, because the facts support murder 2. The facts do not support murder 1.
Okay.
Simple as that.
Okay.
Trying to keep it short.
No, I appreciate that. And we'll have you back for 3 minutes of rebuttal. Thank you.
Thank you.
Why don't we hear from the government? We have AUSA Siegel.
May it please the court, Jonathan Siegel for the United States. I also represented the government below. I would like to start on the issue of knowing, voluntary, and intelligent. And I do think that they are related, as I think we've all touched on. But the requirement for a plea to be knowing and intelligent and voluntary is that the defendant understand the elements. And the record here is clear and I think really undisputed that the defendant did understand the elements. It was explained by the judge. It was listed in the indictment. He confirmed he'd read the indictment. He confirmed he understood the elements. The dispute here is really not about the elements, but about a defense. And the law in this circuit is that you do not have to advise a defendant of any defenses during a plea allocution in order for it to be knowing, voluntary, and intelligent. And that's the Smith case, which is cited at pages 28 and 49 of the government's brief. And that case explicitly addresses this issue and explicitly holds there is no requirement to advise a defendant of a defense during the plea allocution in order for it to be knowing, intelligent, and voluntary. And that's to say nothing of the fact that this is plain error, where certainly where this is under precedent there is no error at all, there cannot be plain error. I think it's also important to note, while Mr. Bachrach said that defense counsel didn't know about this defense or hadn't thought about this defense, they actually explicitly mentioned this defense and raised this defense as a possibility in their sentencing memo, but then explicitly said, we don't want to raise it, we're waiving it because we want to fully accept responsibility. So I think under every prong of plain error, the challenge to the knowingness and voluntariness and intelligence of this plea fails.
And under the fourth prong of plain error, we could look at events even post-dating the plea to make these kind of determinations.
Both the third and the fourth, as to whether this affects his substantial rights, whether he would have pleaded guilty anyway had he been advised of this defense. The fact that at sentencing, in his memo, he says, there is this possible defense that we could have raised at trial, but we're not raising it.
Where is that in the record? Do you have a citation for that?
I do, Your Honor. It's at docket entry 115, page 32, footnote 18. And I apologize. I think there's both a sealed and an unsealed version of the defense memorandum. 115 is the sealed version, but it's on page 32, footnote 18, which is both in the sealed and unsealed version.
Is this in the appendix?
It's not in the appendix, but it's cited in the district court docket, and it's
Did you mention this in your brief?
yes, repeatedly. I can get you the page sites for that as well, if that would be helpful.
Oh, I think I have it here on page 14. I've got it. Yeah, no, you mentioned it on page 14 of your red brief. Thank you. I got it now.
Turning to the factual basis, I think our first argument, which has been touched on, is that was fairly clearly and explicitly waived, and for good reason. As Judge Nardini noted, there was a real tactical benefit to getting past the plea and getting to sentencing, and to really say as little as possible to not get into the really gruesome and grisly facts of this case. When the judge asked, is there more that's needed? The defense said, no, there is no more that is needed. At sentencing, when this issue began to crystallize, when the defendant was adhering to his claim that she had slipped in the shower, the government said, that seems to be a little bit in tension with your plea, and you can't do that. And again, at sentencing, they said, this is not in tension with our plea. Our plea is sufficient. We stand by our plea. At every opportunity where this was raised, the defense did waive it. They waived it strategically and tactically, and the fact that it didn't work and he still ended up with a life sentence is not a basis to walk away from it now. But I think also on the merits, it's important to address that really it fails for the exact same reasons as the attack on the knowing and intelligent and voluntary nature. The same Smith case that I cited previously also addresses the factual basis requirement and says that you don't need to rule out every possible defense in order for there to be a factual basis. At this plea, he allocated that he approximately caused her death, he did it in the course of sex trafficking, that he did it with the intent to cause serious physical injury, and that he acted recklessly with total disregard for her life. That establishes all of the elements, that provides the factual basis for every element of the murder count that he was convicted of. And again, there isn't really a dispute about that. The dispute is whether he offered a factual basis to defeat a defense, and the law in the Second Circuit is that you don't have to. That's particularly true here, where there was no mention of this possible defense at the plea hearing or in anything in the record at the time of the plea. And this court's precedents make clear when assessing the factual basis, you look at the record that exists at the time of the plea. So for that reason, in addition to waiver, there wasn't any error at all. There certainly wasn't plain error. And then moving on to the third prong of plain error of, does the record overall support the fact that there was a factual basis? Ultimately, at sentencing, there was the grand jury testimony admitted of Jane Doe 8, where she discussed the defendant's confession, where he admitted to her beating Leandra Foster to death. The court explicitly stated that she did not credit the defendant's version of events and did credit Jane Doe 8's version of events. Based on that, there's no prejudice to the defendant's substantial rights, because the full record, which can be looked at on the third prong of plain error review, does show that there was a factual basis and that he is in fact guilty of murder. And then finally, as to the fourth prong of plain error review, here, I think the same arguments for waiver, even if somehow he escapes waiver, really do weigh heavily in the fourth prong of plain error review about the respect for the legal process and fundamental fairness. The idea that someone can come in and say, I want to plead guilty, this is sufficient, I don't want to go to trial, I want to accept responsibility. And then when it doesn't work, after the victims finally get closure, after, for some of them, decades or over a decade, to turn around and say, no, I want to do it all over again because I got a life sentence, that would really undermine respect for the
So
law.
that waiver or invited error, however you want to frame it, that argument, in your view, does that go to both of the arguments contesting the plea or just the factual basis argument?
I think the waiver is really only for the factual basis, but for the voluntary and intelligent and knowingness, there's just so clearly no error and no plain error under.
So I
Smith.
understand you're saying that you don't think there's merit to that, but you would only apply the waiver or invited error, however you want to frame it, as to the factual basis component of that argument.
That's right.
Okay, I just want to understand that.
Finally, as to the sentencing claim, while the government does submit that Judge Ammon did correctly calculate the guidelines and that under Amendment 591 that it was mandatory to do it, and as Judge Nardini pointed out, to the extent there's any sense that that was inappropriate to the facts, it was purely advisory and the judge could have varied from it. But the harmlessness here is really unsurmountable. Judge Ammon made an absolute explicit record. I am aware of this issue on the guidelines. I'm aware of this specific issue on the guidelines. And although I have calculated it this way, it does not matter. Even if the defendant was right, I would have imposed a life sentence no matter what. And I think the key case for that, we cite this on page 57 of our brief. It's United States versus Darrah, D-A-R-R-A-H, which is a case from just last year. And it says that there will be a finding of harmlessness where the error dealt with a single enhancement specifically identified by the district court and imposed with the explicit and unambiguous declaration that the enhancement did not affect the ultimate sentence. That is exactly the facts here. So for that reason, both on the merits and on the fact that this is clearly harmless, the sentencing challenge should be rejected.
Okay. All right, thank you very much.
Thank you.
Mr. Bachrach, you have reserved 3 minutes for rebuttal, if there's anything you would like to add.
Just briefly, Judge, a correction. The government spends a considerable amount of time in their brief discussing the fact that we raised the provocation defense and said the provocation was something we weren't going to raise. That's not what we were talking about here. We're talking about heat of passion defense, which is a different defense. So yes, we waived provocation. We didn't waive heat of passion. That argument is different and distinct. With respect to sentencing, Your Honor pointed out, and my colleague here, Mr. Siegel, just pointed out that because of Booker, the guidelines are never mandatory. That's true. But if you read the sentencing transcript, that's not clear to Judge Ammon, because during the sentencing, she believes that because only one guideline is listed in the cross-reference sheet for 18 U.S.C. 2245, and that one is the one related to first-degree murder, 1A 1.1, she believed she had to apply that. That is incredibly clear at sentencing. She didn't think she had any discretion to be able to vary from that and apply 1A 1.2, which is, 2A 1.2, which is for
Well, to
murder.
depart from it.
What?
She may have believed she had no basis within the framework of the guidelines to depart, but you're not suggesting she misunderstood Booker.
No, what I'm
I
suggesting
mean, we
is that
usually vary usually to mean something as an outside the guidelines framework.
No,
thought.
she didn't misunderstand Booker.
All right.
She believed that the guideline she was required to apply was in fact and could only be the guideline associated with murder one. But here, the facts don't support murder one, since the defendant, as the government conceded, it was not premeditation. The government also concedes that none of the enumerated offenses that are the
Assume
alternatives
for the sake
also
of
don't apply.
argument that there was no heat of passion.
Sorry?
Assume for the sake of argument that this was not done in the heat of passion, because I know that's your position. Assume it's not. Would the factual basis have been adequate?
At the time of the plea,
Yeah, assuming that there was no heat of passion. I know that's a hypothetical that you don't want to accept. So in an alternate universe where there was no heat of passion, would this be an adequate factual basis?
it doesn't address it because the allocution doesn't address state of mind. It specifically says, I intended to hurt someone. It doesn't say I intended to kill someone. It doesn't address whether or not he did so in a cool-headed, in a cool mind, where he in fact reflected at least for a short period of time. Those are the requirements under Mulder, United States versus Mulder. Those are the requirements of first-degree murder. The allocution does not touch on, did he have a cool mind? Did he think about it? Quite the contrary. He never even says in the allocution that he killed her. Regardless the term, murder, and there's a difference between murder and manslaughter. Killing is killing. He doesn't even say that. He simply says, I assaulted her, and as a proximate cause, she died.
Okay. All right. Well, thank you very much to both sides. Very well argued. We appreciate both counsels appearing today. We will take the case under advisement. Thank you all. We'll now turn to 25-8. Alejandro Aguilar Díaz et al. Versus Bondi.
May it please the court. Parole is nothing more than a release from custody. The parties all agree that at the time the petitioners were released from custody, they were subject to mandatory detention under Section 12.
Well, hang on a second. I'm going to push you right back. We've said, are you suggesting this unity of parole there's only one kind of parole? All parole is the same parole?
No, not at all.
Okay, so parole is more than release from custody. I mean, there are two kinds of parole, right? Before we go anywhere, I just want to make sure that we've held, what's the name, Cruz, Miguel, what's the name of the case? We held, right, that there's humanitarian parole is not the same as conditional parole. We're not going to fight that battle, right?
No, not at all.
Okay.
But under Lengmei Ma versus Barber, parole under 1182D5 is simply a release mechanism when someone is not entitled to seek release. So basically, 1226 conditional parole is when the government has discretion to release the person. Humanitarian parole, 1182D5, is when that discretion does not exist, as is the case with 1225B2. That's how the statutes have worked since the 1952
Yeah,
Act.
but you agree these are two different things we're talking
Yes,
about.
absolutely.
Okay, good. I just want to make sure you weren't starting with the premise that all parole is the same. Got it.
No, not at all. We recognize there's two different frameworks. They are independent of each other and mutually exclusive. Our claim is that our clients were under the 1225B framework when they were detained and released, and the only legally possible.
How do you get there rather than 1226, which is what apparently they were released under, at least in terms of the documents?
So setting aside the documents, Your Honor, I think we have to look to the law first. It's substance over form. So the law, they were applicants for admission under 1225A1. We all agree on that. They were arriving in the United States as opposed to just simply being present. And if we look at 1225B2's language, it applies to applicants for admission, which my clients were, and they were in the process of seeking admission because they were arriving at the border. So then they fit within the terms of 1225B2. Now, I understand in the past, it has been understood that there's an overlap between 1225B2 and 1226, but after Jennings versus Rodriguez, that's not the case anymore. And the government agrees. From my understanding of the brief on that.
Yeah, well, maybe you're all wrong. But I guess I have another question, unless Judge.
No, go ahead.
It seems like we're engaged in, there's two debates here, right? One is, what should they have been detained under and how should they have been released? And one is, how were they detained and how were they released? And I understood that for adjustment of status, the question is whether they were paroled. Right? If they were paroled, right? In fact.
Yes.
So let's say, for the sake of argument, that an IJ, they come before an IJ, and the IJ said, I invoke the Bail Reform Act of 1984 and I release you. Because that's what criminal law says. And we look back and I say, well, that's nuts. Criminal law has no application here. But would you say, oh, so they must have made humanitarian parole decision. They must have engaged in the public benefit or the humanitarian benefit analysis. Well, we know that they didn't. Would you say, well, even though the judge didn't parole them, you seem to be trying to say, well, he ought to have paroled him, but we know he didn't. So why are your argument is this historical revisionism argument that's saying, yeah, it doesn't really matter what the immigration authorities did, it's what they ought to have done. Why would we do that? Why would we engage in analysis of not asking what happened, but what ought to have happened?
Because the rule of law, Your Honor, it's a legal impossibility. For
Okay,
them.
so let me take my hypothetical. Crazy immigration judge invokes the Bail Reform Act. They acted illegally, but you're saying they were in fact paroled? Why can't judges make mistakes? Why can't immigration authorities make mistakes, do things that in your view are totally wrong? But then you would say, well, I'm going to deem them to be something that was right, even if it's not something they ever did. And, stick with my hypothetical.
Well, with the immigration judge, they don't have parole authority. So there's no situation where one could claim that an immigration judge has paroled somebody. But let's say DHS.
Let's say DHS said, I invoke the Bail Reform Act of 1984 and I release you.
The actions of an administrative agency must always be judged by their authorized, the authorizing acts, the law.
So let's say then they weren't authorized to do that. They did something unauthorized. Let's accept that then. Well, because that's why I gave you a ridiculous hypothetical, so we can all agree they acted completely ultra vires.
I think this is a debate about whether to call it a tomato or a tomato.
No, I'm saying tomato watermelon. They came in and I'm serious. They said Bail Reform Act of 1984. Just stick with my, okay, I'm taking an extreme hypothetical to illustrate what might be the limits, of, let me again call it historical revisionism. If an agency does something completely ultra vires, in your view, do we get to recharacterize it and basically say, even though we know for a fact they invoked a criminal law, because the only way that they could have legally released them, assuming, is through humanitarian parole, we have to pretend that that's what happened. Isn't that basically what your argument is? No.
So going back to the Cole de Bella memo and the old INS memos, in 2007, DHS made a decision, this is how it was working back then. Even if we use the wrong paperwork, we're going to treat them as parole. But we don't like that they're getting benefits if we do that. So we're just going to change the way we view the statute and start giving them this piece of paper.
But you got to convince us that's right. I mean, maybe INS was right, or maybe they were wrong, but you got to convince us that the historical revisionism is correct. That you can go back and say X happened in the past, but we're all now going to act like Y happened.
So in matter of O, the BIA's own precedent in matter of O was 125 Cambodians that were brought into the United States on a plane, and they were given some document that was not parole, and they needed to be paroled for whatever purpose they were seeking in their proceedings. And the board said, no, that could not have been parole. The law says when you're trying to enter the country, you're supposed to be detained, and the only way you could have been released was parole. They treated them as parole. They declared that the act of the release was a parole because it's the act of the release that we're talking about. It's not the piece of paper. They could have given them no
paperwork. Have we ever said that?
All.
I mean, I get it. You're talking about the BIA said that.
And the Vitali versus INS in the Seventh Circuit.
How about us? Have we ever said that?
No, this court has not done.
So we've never gone back and said, even though an agency did X in the past, because we conclude that X would have been illegal, we're going to pretend that actually Y happened because Y is the only thing they could have legally done.
I would say that Congress made that decision with the IRIRA because under the reenactment canon, when there's agency precedent and case law from the courts of appeals in place with certain understandings, and the Congress does a full overhaul of the statute and does not disturb any of those precedents, it's understood to have adopted and continued that practice.
And that has to be sort of a widespread and understood, generally understood practice. Where do we get that from? It sounds to me like
Well, matter of
episodically, a few things may have happened here and there, but
Well,
Isn't
matter of O is of a national precedent. It applied across the whole country. And it came after Vitale and Medina Fernandez.
and how did IRIRA
It never changed
memorialize that?
by not changing it.
So when you say it, tell me what's the it?
Okay, so-
Because I
so-
didn't think there was anything in the statute that said something like the BIA said, oh, this allows us to recharacterize what happened in the past, and now that statutory language is there. I think you're just saying that there is a practice that happened maybe once, maybe multiple times. Congress never passed a law to prohibit it, but I don't see that there was a root piece of statutory language that authorized this recharacterization that was never amended. Is there? Or is there some statute that says thou can engage in historical revisionism in whatever language you would?
I understand how you're looking at
And what's the
issue.
statutory language?
No, there's no statute. What I'm saying is that when
So hang on. If Congress enacts a statute, we assume that how the courts have been interpreting and applying the statute has been sort of implicitly reenacted, right?
when there's a major overhaul.
Well,
So
but
that's
my
the
question
reenactment
here is,
canon.
what's the part of the statute that you're saying that by reenacting X provision, they have now adopted the interpretation?
1182D5. So the parole statute, the parole provision was written in 1952. And I'm sorry, this is not in the briefing. If we could do supplemental briefing or the court would allow it, I'd be happy to get.
We'll tell you if we need briefing. So you're saying that simply by reenacting 1182D5, which is the humanitarian parole, that
This is Supreme
it-
Court doctrine. It's the reenactment canon.
no,
When
but that's a
they're-
generic. Yes,
Well,
we get that.
so what I'm saying is the 1182D5 has never been changed, except for the case-by-case determination language, but it doesn't have to do with the core entirety of the statute. 1225B was a mandatory detention statute prior to IRIRA. They modified it, but these schemes of interlocking provisions were always there. The courts of appeals in other circuits began looking past the documents and saying the law controls apply it to the facts. The board did it in a national precedent. Congress is presumed to have been aware of that. And when Congress was in the process of overhauling the entire statute, administrative practices, at least ones of national scale, such as matter of O, if they're not directly changed, they're presumed that the old soil comes over.
So let me ask you this.
And nothing in IRIRA
IRIRA,
overturns any of this.
Yeah, so with all the enactments and overhauls, are you saying then that your argument under 1225 is completely wrong? Because hasn't Congress continually been reenacting all of these various chunks and pieces of the immigration statutes that were consistently applied not to adopt your underlying theory of 1225? It seems to me that you're treading on dangerous ground when you say, well, implicitly, whenever Congress keeps overhauling these statutes, they're implicitly adopting all of the administrative practice that came
They've
before.
never changed it. The point
Right,
is,
and my point is that
the
if they've
matter
never
of
changed
all-
hang on.
sorry.
If they've never changed 1225, then how do you even get to your underlying theory that your clients were actually secretly all along being detained pursuant to 1225 if Congress has been reenacting these statutes all along with a consistent administrative practice that people were not being detained under 1225? How do you get that?
1225 was expanded in its scope. So before 1225 only applied for someone arriving at a port of entry. We're saying that under IRIRA was expanded, and that scoops in people like my client. They were subject to mandatory detention. Now, the concept that you can look to the detention statutes and the release statutes is something different. The idea that you can look at it and determine that as a matter of law, what really happened was parole versus what the paperwork says, that's a separate issue. That has never been changed by Congress. So if you separate those two concepts, the change is that persons like my clients are now subject to mandatory detention. But our reliance on the procedural regularity doctrine, which has been started with the courts of appeals in the 7th and 9th Circuit in the 50s and 70s, the board adopted it in matter of and Congress has never changed that. That has been undisturbed. The board has never changed that precedent. It's still in place. First of all, the agency is still bound by that decision in matter of which they didn't follow and just seemed to ignore. And we did bring it up in our brief. So that right there is an abuse of discretion on the board by failing to follow its own precedents. But even then, what I'm saying is that that precedent that's still in place with the board, Congress chose not to disturb it, and it's presumed to have adopted it, and that the courts of appeals therefore can do what the board did in matter of and in the Medina Ferdanis case, and in the Vitale case. And I'm seeing it well past my time.
Yeah, you've reserved some time for rebuttal. We'll see you again. You've reserved 2 minutes. So why don't we hear from the government?
Thank you.
May it please the court. My name is Jonathan Robbins, and I'm here on behalf of the United States Attorney General. Good morning to your honors. The key issue in this case is whether the Board of Immigration Appeals properly upheld the immigration judge's pretermission of the petitioner's applications for adjustment of status under the Cuban Adjustment Act. In order to be eligible for Cuban adjustment, the petitioners had to show, among other things, that they were either admitted or paroled into the United States. And the board upheld the immigration judge because the record unequivocally demonstrates that the petitioners were released on their own recognizance under the 1226 framework. They were granted conditional parole, and under board precedent and this court's precedent, as Your Honor mentioned, the Cruz-Miguel case, that conditional parole is not sufficient to meet the admission or parole requirement for Cuban adjustment. Now, I think Your Honor has it right when you've characterized the petitioner's argument. He's left basically to argue that even though his client was not granted humanitarian parole, because he should have been detained under the 1225 framework, he effectively wants to convert the grant of conditional parole into a grant of humanitarian parole. But there are numerous problems why the court shouldn't do that. And I think the best place to start is probably with the statute. The parole statute itself places the discretion for granting humanitarian parole with the Department of Homeland Security. So if this court were to, in the first instance, create a legal grant of humanitarian parole, it would effectively be usurping the discretion that the statute puts with the Department of Homeland Security. I would also
remind me then, the facts of this case, the record.
Mm-hmm.
Who issued the order of conditional parole?
That was when DHS released him. Those orders are located on the record at I think it's 40. Sorry, let me just get the exact page here. These are the orders.
If you can just point, excuse me, to the page of the administrative record, it's probably the easiest thing.
Sure. Just one moment.
I just want to make sure I'm understanding.
So it starts on page 221. That's a list of the different warrants for arrest and the notice of custody determinations, and interspersed with those are the 3 different orders of release on recognizance. So the first one, they're sort of interspersed. The first one is on page 225 of the record. The next one is 227.
And that's signed by an ICE official, right?
Yes, that's an ICE form, yes.
So I guess,
Could you finish?
Yeah.
You had 3 of them.
Sorry, 225, 227, and the last one is, sorry, I just lost my place here. It looks like 234.
okay. So those are the documents, the order of release and recognizance with the various addendums.
Right.
Signed by an ICE official. I just want to make sure I'm understanding this narrow, at least this piece of your argument where you say recharacterizing a grant of conditional parole to humanitarian parole would usurp the authority of DHS. But the ICE official who releases someone on recognizance is a DHS official, right?
Yes.
So it's not so much that we would be usurping the authority of DHS in the sense of we would be saying that some other non-DHS official was allowed to do it, like say an IJ or something. We would simply, I think what they're asking us to do is to say, no, this is DHS acting, and we're telling you what DHS did. So there's no real usurping it and saying, well, someone else is making the decision. We're saying, no, this is what DHS did. So I guess I'm not, unless you're saying the very act of recharacterizing what DHS did is the usurping of DHS's authority. Is that what you're saying?
Well, here's the problem, and this was actually getting to the next thing that I was going to talk about. If you look at the parole statute at 1182 D5A, it does say that this is in the discretion of the Department of Homeland Security, but it doesn't stop there. It cabins that discretion to limited circumstances. It uses the word only, and it says that the DHS is only supposed to exercise its discretion to grant parole on a case-by-case basis when there is a humanitarian concern or a significant public benefit. And so what I'm talking about usurping there is not just discretion. You would essentially be having to make factual findings that DHS has never made about whether there's a humanitarian concern and whether there's a significant public benefit.
Would we have to? Or again, if hypothetically, if we accept your opponent's invitation, we're simply saying that must be what DHS did. We're not making any findings. We're just going to assume that DHS must have made those findings. They didn't put them on the record, but I guess they were in the ICE official's head.
But we know that that's not what happened, though, because we have the evidence that shows that they were released on conditional parole.
And it says, and I'm just looking at page 225, which is the first page, and it said, in accordance with 236, which is 1226, right, of the Immigration and Nationality Act, you were being released on your own recognizance. So your view, as I understand it, is this is documentary evidence. If we're wondering what happened in the past, if we're wondering what happened in 2021, we have contemporary evidence that the agency was acting pursuant to 1226.
Exactly. And that really can't be changed. That's a matter of historical fact. There are things the court can do by operation of law, but you can't change the fact of what happened. And the problem is that it'd be one thing to say that you could maybe say something is equivalent if we were looking at interchangeable cause. If conditional parole were something equivalent to humanitarian parole, then maybe you could, figure out some way to say that they're interchangeable.
Is the government's new position, which opposing counsel shares, which is people like petitioners are now subject to mandatory detention under 1225. They're not subject to detention under 1226. Is there any reason, if we were to agree with the government, that this court would need to engage with that issue to rule in your favor? So answer that. And then the second question I will have is, maybe this is a question for the other side. Would we, however, need to engage in that if we wanted to rule in favor of the petitioner?
Okay, so just to clarify, if the court disagrees with the government's new position, this is a new position that's been recently introduced, this interpretation of the statute. If the court disagrees and thinks the government is wrong as its new position, then the case is open and shut. Then DHS did properly detain petitioner under 1226, issued conditional parole, and Cruz Miguel would foreclose the petitioner's argument. And that's the simple way if the court disagrees with the position. If you agree with our position, I don't think it matters to the outcome of this case.
No, my point, if I wasn't clear, do we even need to agree or disagree
No.
to take the position that I think the government's taking, which is whether the petitioners were granted humanitarian parole is a question of fact, not of law. And the facts are shown on page 225, et cetera, of the record. If we were to adopt that position, would this panel be required to even engage with the question of whether the government's right about this more sweeping issue about whether people ought to be subject to detention under 1225 as opposed to 1226?
No, you would not need to engage with the 1225, 1226 issue.
And then I think this is where I was going, and maybe on rebuttal, counsel can answer this. But my understanding is that in order for the petitioner to win, we would have to engage in that analysis, and we would have to agree with both of you that yes, in fact, 1225 is the only proper way that the petitioners could have been
I think that's
detained.
correct, yes.
And then we'd have to take the second step of saying, and we should recharacterize what was done in the past to conform to our understanding of what the law provides.
Right, because
Okay.
there would certainly be no basis to recharacterize conditional parole as humanitarian parole if it's not the 225
So
authority.
just to clarify something for me, to what extent were these arguments that you're making, your adversary is making now, presented to the BIA?
Well, the petitioner actually, it's a little bit unusual. Most of the time with the 1225 argument, the immigration bar takes the position that 1225 does not apply to situations where, like the petitioners are in. But the petitioner did argue before the immigration judge and before the board that 1225 was the detention authority that he should have been detained under. Now, at the time, the government disagreed with that because for a long time, up until the new administration, the government was treating 1226 as the appropriate detention authority. That position has changed, and that is currently being litigated. In fact, I think it's coming up in a case before this court as well. It's beginning to percolate in the courts of appeals.
That may be the argument. My question is the BIA's views are not known on this. Is that accurate?
Well, the BIA's views are known on the 1225 issue. The BIA has agency decisions, and they're actually cited in a 28J filed by the petitioner. Matter of Hurtado and matter of Q. Lee. Matter of Hurtado is the one that's most directly on point with respect to the applicability.
But don't they conflict with prior rulings, which are still operative with regard to 1225 and 1226?
Well, they conflict with the government's prior practice, but I don't think they conflict with prior board decisions. One of the things that the board discusses in the Hurtado case is that it hasn't been really addressed.
Mm-hmm. One question I have is whether there's room for the BIA to be heard on these questions. Neither of you are asking for any of that, but one question would be, and I know that this was raised in the 11th Circuit, that perhaps it ought to be sent back to the BIA. And I just wondered what your views are on that.
Our views is that it's not necessary in this case. I mean, I don't think there's any harm in doing it because the board can't, if it goes back to the board can't grant parole, right? It can't grant humanitarian parole.
And I understand that, Loper Bright is in place. So there's no Chevron deference in this case. But by the same token, if the board rules, given all the new information that it would have, we might be helped by that. And we might not be. And it's sort of like sending a case back in this context to the district court, in which we ask the district court to sort through these issues, which, at least for me personally, are not simple. They're quite complicated, and they depend upon what happened over different periods of time, and the effect of certain provisions, and then the government changes its position. So why wouldn't we want to send it back just for the benefit of getting another judge to look at the problem, or judges to look at this problem before we actually have to make a decision?
Well, Your Honor, if the court thinks that it would benefit from a board decision, I don't see any harm in sending it back.
Well,
the government's position is
benefit
that,
or not benefit. I mean, board decisions might be right, they might be wrong.
Well,
You know, but that's true of district courts when you send cases back.
fair enough, Your Honor, but that's the government's point as to why we don't think it's necessary,
I see.
right? I mean, if you want the board to opine on it, I mean, it will take.
Well,
a lot
maybe it's
longer.
not necessary. You're
Yeah.
right. Maybe but we'll
It'll
see.
take a lot longer, but
But following up on Judge Walker's question, what would the government do if we were to remand it? Would your position basically just be a replay of your red brief here, or what would the government say to the BIA?
well, if you remanded the case and vacated the order of removal,
Yeah.
well, the vacating of the order of removal would mean he'd be back on. He would be fall under 1225. So this is where it gets a little complicated. So the government's position is certainly that 1225 applies as the detention authority, and that detention is mandated for individuals in petitioner
And I'm sorry, I
situations.
should know this. Are they presently detained?
No.
No,
But would, if we remanded it, the government would take the position that 1225 applies? Would you then take the position that they should be mandatorily detained?
Yes. However, I want to sort of explain the practical
Yeah.
implications of that. So the agency, the government's position in the 1225 litigation is that it doesn't have an affirmative duty to go out and get people who it's sort of like prosecutorial discretion. If they're out, if they encounter them, they're mandated to detain them, but they don't have an affirmative duty to go out and, you know, find people who are subject to mandatory detention. That's the government's position in that course of in the 1225 and 1226 litigation.
so your position would be 1225 would control, but they were not paroled under 1225. They were paroled under 1226. You
Correct.
adhere to that position.
Correct. And there's one other sort of wrinkle here that I think is worth pointing out.
Before you
Oh,
get
yes.
to the new wrinkle, does this depend on the date on which they were detained?
No, Your Honor.
The application, the applicability of 1226 or 1225, does that depend on the date that they were, when they were detained?
Well, the government at the time they were detained in 2021, the government was taking the position that 1226 was the controlling statute. The government now has taken the position that that was not correct, that it should have detained them under 1225. That's been the change.
Regardless of what date it was and what stage they were detained.
Right.
Okay.
But just to sort of talk about this wrinkle that I was discussing, when the petitioner is released, they can still apply for humanitarian parole. Right? It's sort of colloquial known as parole in place. Normally, when somebody applies for parole, they're for people outside the country, but people inside the country can apply for humanitarian parole. So when they were released here, I mean, the petitioners are saying, well, it's the only way we could have been released. It's so you should say that this was humanitarian parole. But even after their release, they could have theoretically sought it before DHS. I don't know that they would have been granted, but again,
And are you saying that they could still do that? Oh.
To be correct, under 1225, to follow their argument, they don't deserve humanitarian role. They could become, the best he can do is to say they become eligible for it.
right, they would be
But
eligible.
then it has to be ruled on administratively.
Right, DHS would have to determine by statute whether there was a humanitarian concern or a significant public benefit. That's what the statute says. It says it can only be granted on a case-by-case basis if those factors are met. So
Do they wind up, are you suggesting that if there were a hypothetical remand to the BIA and the government took the position that now 1225 would be the statute governing their detention or potential detention, that the government would view them as eligible or in a place where they could seek humanitarian parole at that point?
yeah, if that's the mechanism by statute.
Would you then be taking a position, though, that they're sort of stopped as a litigation matter from claiming that they already got humanitarian parole if they're now asking for it? You know, does that put them into a catch-22 where to ask for something that you think you already have is sort of admitting that you don't have it to begin with?
Oh, I see what you're saying. Well, if the court ruled and said that the government the conditional parole doesn't exist and it was actually a grant of humanitarian parole.
Well, sure. No, if we say it, it's done. But I'm talking about the hypothetical remand situation where everything's in play before the BIA. You seem to be suggesting they could still ask for humanitarian parole. I'm asking whether that puts them into some sort of a bind, because if they ask for it, is that going to be viewed by the government as an implicit admission that they didn't have it to begin with, because why would they ask for something that they say they already have?
Well, I mean, I'm just saying that because the facts show that they didn't get it and that they were granted, as a matter of fact, they don't dispute that they were
No, I know,
granted
but this
conditional
has
parole.
become another quiver in the arrow, or another arrow in the quiver of the government to say, and it's yet more proof that even you are effectively conceding petitioners that you don't have it, because if you did have it, not only does the paperwork show it, but your very request for humanitarian parole shows that you think you don't have it. Yeah, I know, the red light's on. Keep going.
Oh, sorry. Well, I mean, I understand Your Honor's points, but I mean, I don't know that I can say anything other than what I said. They can go to DHS at any time. DHS has the discretion. There are forms to file. They can ask for parole. If they're applying for Cuban adjustment, one of the requirements is parole. If they don't think they've been paroled, go and ask just for parole. I'm not suggesting it would be granted. I'm not trying to create any false hope. There's one final thing that the petitioner mentioned, that case, matter of O. Matter of O preceded the current statutory scheme. It was based on a parole stat. The parole language is different. It's similar, but different. DHS didn't actually exist at the time of matter of O. So the parole statute there had to do with the Attorney General's
This is
discretion.
1977, right?
Matter of O,
Matter of O. If
think
I'm
it
looking
might
at the right one.
I don't remember the year, Your Honor.
Okay.
But that was there was different language in that parole statute. It was slightly broader in terms of discretion. As I explained, this current version uses the word only. It says that it can only be used on a case-by-case basis for humanitarian concerns. The language of that prior parole statute for the Attorney General in matter of O was slightly different. It didn't have the term only, and it was similar language like emergent reasons or humanitarian concerns, but it didn't cabinet it quite in the way that the current statute cabins it. And so I don't know that analysis. I would also point out that in matter of O, there wasn't a fact that showed demonstrably that they did not get a grant of parole. They were sort of figuring out, well, was it parole or was it not? Here we have definitive evidence that shows they got conditional parole, which case law makes clear is not a grant of humanitarian parole. So unless Your Honor has any more questions, so thank you very much for your time.
Thank you very much. Mr. Prada, you've got 2 minutes for rebuttal. So if there's anything you would like to follow up on,
Yes.
we'll try to keep it to 2 minutes.
Yes. Looking to the record, the petitioners entered the United States July 26, 2021. A warrant was not issued until 11 days later on August 6, 2021. You cannot detain someone under Section 1226A without a warrant. It's arrest upon a warrant. However, 1225 is warrantless arrest. So looking to the facts in the record, they were detained under 1225 until 11 days later that the government decided to paper it or something differently. And this is an argument we put before the board. Going back to your catch-22 question, that's actually a problem that has arisen in one of our cases in the Southern District of Florida, where we're trying to certify a class and the government is arguing a lack of commonality because some of the named plaintiffs did seek parole in place while others did not. So for your question, yes, that is something that would complicate the case for us. And we don't know what an IJ or the board would say, and it just adds an extra wrinkle and more problems for us.
This is to go back to Judge Walker's question. If we were to remand this thing to the BIA, just let the BIA think about it, how would it play out in your mind? Not how would the BIA rule, but what would your pitch be to the BIA?
Essentially the same brief we already filed, but citing matter of QLE, and that's also your question about how far you need to interpret 1225B or not. There's the two cases, matter of QLE and Hurtado. QLE is the much narrower view, which we are arguing is correct. The Hurtado case is the one in the habeas litigation across the country. So if the court focuses only on QLE, they're not touching upon what's happening in the habeas cases, right? But to your question again, I don't think there's any conflict between the board's decision in QLE and any of its prior precedent. There's no reason for the remand. There's nothing for the board to elaborate upon. We presented the issue to them squarely that it is today, and our argument will not change. Thank you, Your Honor.
All right, thank you both very much. We will take the case under advisement. We appreciate the arguments. We'll now turn to the last case on today's calendar, 25-113, New York Presbyterian Hospital versus New York State Nurses Association.
Bueno, bueno, bueno. Saquen sus propias conclusiones. No fue muy bueno que digamos, a mi modo de ver. Voy a dejarlo ahí para hacer